one of the main questions that we often get is, what are victims' rights in the military, and how much overlap might there be between the military rights and the rights that civilian folks might be familiar with in their own systems? So I'm going to put on the screen an example of civilian victims' rights. This is what everybody will recognize as the CVRA, the Federal Crime Victims' Rights Act. We've got some really core rights that exist in there, and I'm going to do a very brief overview. I'm guessing that everybody on the line is already pretty familiar with victims' rights in their jurisdictions. And from jurisdiction to jurisdiction, most places incorporate these same core rights that are included as part of the CVRA, which includes the right to reasonable protection, the right to notice of court proceedings, the right to not be excluded. And that the wording of that one always makes me grin a little bit. Most non-federal jurisdictions have used the more affirmative phrasing of the right to be present instead of the right to not be excluded. Rights to restitution, rights to confer with the attorney for the government, whoever that person is, the right to be reasonably heard, the right to proceedings free from unreasonable delay. And in some jurisdictions, we're calling that sort of a speedy trial right. They phrase it in that way. The right to be treated with fairness and respect for their dignity and privacy, and the right to be informed in a timely manner of plea bargain and deferred prosecution agreements. So most civilian jurisdictions have rights that look similar to these, either in constitution or in statutes or in rules. And many civilian jurisdictions go beyond this to provide additional rights. And one of the really common and very beneficial additional rights that's often found in civilian jurisdictions is the right to refuse defense discovery or interview requests of the victim of crime. So this is just a general overview of common rights. And I'm going to move to the next slide, which gives some examples of similar rights that exist in the military system. And I'm going to go ahead and turn that over to you to talk a little bit about the military rights. And we've used a little bit of color coding here as well.
So these being legal rights, I'll kick it off as the attorney. And you'll see that some of these ones are color coded because the implementation sometimes can get a little convoluted. So I'll jump off with the one that is actually not something that a lot of our victims ask for, but it's in green, and that's restitution. And the reason that that gets convoluted is that the military criminal justice system is set up already as having a sentencing option for a fine, as well as a sentencing option to forfeiture of pay. So those two types of things, a fine, we're used to that in the civilian jurisdictions where the court could order a fine and that would then get collected by the court to go to the local jurisdiction. Well, for the military, that is going to be a fine that would be collected and paid to the Department of Treasury because the United States is the ultimate prosecutor on the case. Forfeiture of pay, very different than a civilian criminal case. Because the military is paying that service member, we have the ability to sentence the person to also say, and we're not going to pay you while you're in jail. And certain jail sentences, if they hit over a certain minimum amount, that's an automatic forfeiture of pay because it's kind of a waste of taxpayer dollars that we're going to pay someone to sit in jail. Now, because we're set up to be able to pull pay from a person who's been convicted in a sentence and leave it in the Department of Treasury or put it in the Department of Treasury, the mechanism for restitution, which is to be able to pull that person's pay or something from their bank account and give it to someone else, is not as fluidly set up. So I've seen that most often occur in other types of cases where we do actually have, say, a theft case or an assault case where somebody has had bodily harm or they've had personal property that's been destroyed. Maybe it was that the person took their motorcycle without getting permission and now they've wrecked it. Now, in non-judicial punishment, so it's not a court-martial, command can take an administrative action to punish a person outside of the court, non-judicial, and they can say, I'm going to confine you to the installation, or I'm going to take away some of your rank, which correlates to pay, or I'm just going to take away pay. And sometimes when there is a situation that requires that the accused also pay back someone else, someone other than the government, the commander may say, I'm going to take away 2 levels of rank or 3 levels of rank. However, I will suspend part of that punishment and give you the next couple of months to pay the person back. If you don't pay them back, I'm going to take that away, or I'll give you a fine. But if you do pay it back, then I won't. And that's the easiest mechanism from a legal point of view because we have it set up, but it's incentivizing a person to do something on their own because the military is not set up that way. We do have it in the Uniform Code of Military Justice to have a victim be able to request restitution. And we have not exercised that very much. And most of the time our victims, their request for something is, the law enforcement, military law enforcement still have my cell phone or my clothes, and I really want to be provided that back. So it's not so much a restitution to the accused, but a request for government to reimburse them for things. And then we have the Federal Claims Act. So that is some of this complicated part. Doesn't come up very much. Another reason why having a military victim attorney can help you. But looking at the other parts, you see a lot of things on here that are the same. To not be excluded, to be protected, that's going to be protective orders, to be treated with fairness. That gets played out into the not having to testify at our preliminary hearings. And a wonderful thing about the military victim rights is that they attach immediately. Unlike a lot of Marcy's laws in states and the state victim rights, the victim does not have to affirmatively request these rights. They are available at the beginning, and we've been pushing the envelope as we go into our appellates as to under which ones could a victim actually go to court, to an appellate court over. But it is helpful that the victim have these right away, which is why actually our victim advocates are the first ones to be talking to them about these rights, because they have these rights whether they ask for them or not, whether they have an attorney or not. So Freya, I will give to you for additional from a victim advocate perspective.
So from a victim advocate perspective, when I'm talking to one of my clients about the rights that they have, I'm going to be talking to them about their rights while we are going through specific paperwork. We have the document where they elect restricted or unrestricted or no reporting, where they do not sign the document. And as we're going through that document, then we talk about every single one of their rights, especially when we're talking about protective orders, when we're talking about mandatory reporting in certain jurisdictions if the incident occurred off the installation. When we talk about protective orders, we have 2 different kinds that we can assist a victim of sexual assault receive. The first one, of course, is a military protective order, and this one is enforceable on the military installation by military law enforcement. The second one is a civilian protective order, and that one is going to a civilian courthouse, getting a civilian judge or magistrate to actually sign off on this protective order so that they can actually receive protection from law enforcement off of the installation. Those are 2 of the really big ones when they're talking about, I need protection. The other thing that we can provide under protection is command support. I can reach out as a victim advocate to the survivor's commander and say, hey, we need a no contact order. And that is one of the things we love about the military justice system, is that a commander can lawfully tell a service member, you are not allowed to talk, interact, or have any interaction with this other individual at all. And if you violate this, then that's grounds for administrative punishments, loss of rank, loss of pay, just as Lieutenant Colonel Watson was saying. When we talk to them about their victims' rights, we are also required to provide them with the DD Form 2701, which explains all of their victim rights. And then we always recommend that they confer with the Special Victims Counsel to get a more detailed legal perspective on what rights they have, especially when we're talking about situations where a survivor may have committed misconduct in conjunction with being sexually assaulted. And the most common incident of that is when we have survivors that are under the age of 21 and they are being provided alcohol or by the accused, the alleged, or by another individual. So the alleged is utilizing their intoxicated state to take advantage of the survivor and sexually assault them. And under legal jurisdiction, legally, this survivor has now committed the crime of underage drinking. But under the military justice system, they are now protected under the Safe to Report Act that provides them protections from being tried for collateral misconduct, drinking underage that leads to sexual assault. Another example, commanders will get them help and assistance in incidents where a survivor following a sexual assault turns to alcohol as their method of therapy instead of actually going to behavioral health. And so instead of punishing that service member, we then would ensure that they go to substance abuse programs, get the help they need, and the command can then refer them, give them a lawful order that they will go talk to behavioral health professionals to deal with that problem. As we see here, the DD Form 2701, this is now required, mandatory, that we provide that to them as a victim advocate, that law enforcement provide that to them, and the SVC provide that to them. That way they are not missing out on what their victims' rights are at any point in the process whatsoever. If you have anything else, Leah, please go ahead.
So the discussion about collateral misconduct, whether that occurred at the time of the assault, right before, or post-assault self-medication sometimes happens. Those are all things that military legal offices are trained on, so that we can also train our commanders about, so that they are not jumping in to take action that would not be helpful to the good order and discipline in the military. But now that we also have the Office of Special Trial Counsel for cases that office will be overseeing the prosecution of, they also then have jurisdiction for anything else. So we don't have to worry about those aspects of somebody misunderstanding it. But it has been a growing area since when we first started with the victim rights and the victim rights program. When I was one of the victims counsels when the Air Force stood this up, training us in December of 2012, we didn't have this as a protection for our clients. So we had survivors being threatened by their abusers who were saying, if you try to report this, I will point out that you were underage drinking, even though that was the perpetrator was the one who got them the alcohol and encouraged them to drink. So we now have that protection. And then it's been a more recent thing to have commanders and legal offices consider the intention of those rules to protect against collateral misconduct, minor collateral misconduct, I'll say. It does not preclude a victim from being prosecuted for major criminal activities, major conduct, but to look at post-offense, post-assault misconduct by the victim that is minor and actually is more indicative of a medical need, because we have mandatory things that set into place, such as if you are doing drugs in the military, it's a mandatory separation determination. So now commanders can take a pause on that and get the input from their medical professionals, from a victim advocate to go, should we instead be having this person seen by behavioral health and get some drug or alcohol treatment and not just be kicked out of the military? So a lot of these things are similar, but then because of the paternalistic nature of the military, the ability to get protection from the accused with a military protective order can be faster, as well as the ability to balance other misconduct. To a civilian jurisdiction, they probably wouldn't be looking at the drinking of a minor, but we make that explicit for our military members.
Great. Thank you both. So our color coding on this slide, as you probably picked up during the explanations, the dark blue, the rights in dark blue are worded really similarly to the rights in the civilian context, so they'll look very familiar. The rights that are in the lighter blue have some military tweaks to reference certain proceedings, especially military-specific proceedings that may not exist in the civilian world. So they're definitely worth taking an extra look at if you're going to dip your toe into the world of military advocacy. And then that right in green, that restitution right, does tend to work a little bit differently. So being able to partner with a military expert to know all of the ins and outs and what might be available in those cases is really crucial as well. And we don't, of course, want to leave you with the impression that just as in the civilian world, there are lots of other rights. In the military world, there are lots of other rights as well. And we have highlighted a few of those here to briefly discuss for you also. Leah, do you want to get us started on those?
For these, I'm giving everyone a pause because it is a lot to be reading through, but some of the more practical aspects of having thought with these when we've gotten them or seen them play out. Previously, it was that any witness that the government intended to call as a trial counsel when I'm prosecuting a military case, I would make sure the witnesses know, by the way, the defense counsel is going to talk with you and you're going to go over to their office and you're going to talk to them. And typically our witnesses were military. So it was the salute smartly. And yes, ma'am, I will go do that because you just told me this and you outranked me. And now I'm going to go sit in front of somebody else who outranks me and is going to ask me questions and I will just answer anything. But I would preface that with, by the way, everything that they tell you, you're welcome to tell me. And everything I told you, you're welcome to tell them. Very free and transparent process. I'm sure civilian prosecutors and defense counsel would love to be able to have that ability for the witnesses to be so compliant and willing to talk. But one of the first things I saw as a victim's counsel was observing that with my client and the kinds of questions that would be asked. And sometimes not very respectful questions, sometimes very out there questions that had nothing to do with the case. And when you think of someone who is junior enlisted or has no military affiliation and they're trying to understand what's going on, and this person who's wearing a fancy uniform and looks like a person of authority that you have to answer questions to, or they wear a uniform and they feel like you outrank me, so I have to. And now they're feeling, so I have to actually tell you about this sexting conversation that I had with the person I'm currently dating now 2 years after the assault occurred. What relevance does this have? But they're having to just answer it. So we put limitations on the ability for the defense to just free for all ask the witness questions, but then of course had to come back to that and say, okay, because the government intends to call the victim as a witness, the defense should be able to also ask them. But they're going to be doing that through their attorney if the victim has an attorney. And we're going to make sure that we're choosing the time and the place and advising, because it can be that that the defense counsel may not get to talk to the victim until a few minutes before they're taking the witness stand. And it's just going to be a pause by the court. But then that's going to give much more leeway to the defense in their questions. So a victim's attorney can advise the client, the survivor, if we do this ahead of time, we can get a preview as to where they may be trying to go. Also, it's going to preclude them from having full broad discretion to ask anything. And that's probably going to be a little easier, but I will be there with you to help object to questions that are inappropriate. And you can take a pause at any point and we can go out and talk about the question before you answer it. So that ties to the first two about how these interviews requests are taking place and how it has to be with the presence of counsel, so that way the survivor is not just being inundated by somebody who outranks them asking inappropriate questions. These rights are attaching, as I said earlier, at the beginning. They're happening at our preliminary hearings, which would be the equivalent to a civilian grand jury indictment that we do, but not having to testify. Some of the most egregious situations were grueling multi-hour cross-examinations at a preliminary hearing, which is not in front of a judge. Mind you, these were preliminary hearing officers with loose, open rules saying, but it doesn't matter. It's not subject to these rules of evidence because we're just at the preliminary hearing. And so that has gotten stopped. And now instead, the victim doesn't have to testify. Most of the time, it's just going to be a paper case with whatever the victim had already given in a statement to law enforcement. And we have put those steps in to cause the rules of evidence to explicitly apply where they were not being applied through all the military courts. Because of the complicated nature of this is one of those reasons where the victim advocate also is there if the person doesn't want an attorney. But the victim advocate can again go, you might want an attorney who can explain what's going on. Because at that preliminary hearing as well, the victim has a right to attend, even if they chose not to testify. But while attending any kind of legal proceeding, if you haven't gone to law school, or even if you have, you often would prefer to have a legal translator with you.
Thank you. Absolutely. So the next question that comes up is, what happens if the rights aren't working as they should, or the rights are not working in a way that the victim really feels that they need to in order to participate fully in the process? So under the CVRA, and of course in different civilian jurisdictions, this can look a little bit differently. Under the CVRA, there is an explicit process set up for how you seek enforcement of rights. And that's done primarily by motion, either in the court where the prosecution is taking place, or in the court where the prosecution would take place if there's no prosecution currently underway. And then if the ruling by that trial court doesn't come out the way the victim had hoped or is legally wrong as the victim or their attorney perceives it, they can seek appellate review using a petition for a writ of mandamus. And that's, in some civilian jurisdictions, it's not set out explicitly like that, but generally speaking, it works similarly with slight tweaks depending on where you're working in the civilian world. And there in the CVRA, which is really nice, there are some timeframes set up to ensure that those motions by victims and attempts to seek enforcement of their rights are dealt with in a timely fashion, because as we all know, courts don't always decide motions quickly. The appellate courts don't always rule on appeals and petitions for appellate review very quickly. And there's language in there set up to make sure that these things don't languish, particularly when a victim is seeking enforcement of their rights in connection with a criminal trial that's already underway or a criminal trial that's about to start, because everything impacts everything else in the process as well. This next slide addresses enforcement in the military context.
So this was not initially something that we had. And one of my first court martials in the spring of 2013 was a case where my client was excluded from the courthouse, and that later became part of the victim rights. But this is pre-Article 6B. And because there was a delay from all the other motions going on, we actually did file a writ on this about the client having been inappropriately excluded from witnessing the court martial. I actually got excluded too, interestingly enough, under a rules of professional responsibility that I had to communicate with my client. And since the judge couldn't interfere with that because he had already excluded the witness who was my client, he was going to exclude me too. Now, in the past, we had to hope that there was this pause because there was not a writ of mandamus authorized for a victim to be able to take a case up to the Court of Appeals on victim rights. And so if there was a pause, you could try to take the case up. And at that time, we were still fighting on a lot of these just basics, right to standing to say anything in the court. So that case that I had not actually gone at the time, but we've subsequently had cases. And it was actually a case in 2015 that really codified this. I'll throw it into the chat for those who want to see. But now we do have a specific writ of mandamus, as the notes will say, for violations, alleged violations of specific victim rights. So this is going to be failure to comply with the Military Rule of Evidence 513, which relates to the psychotherapist patient privilege. This is where the defense is trying to get all the mental health records of the victim, and the trial counsel has gone one way or the other. We never know. But if the trial court has made a ruling that the victim does not believe was in compliance with the law, the victim now has a right to be able to appeal that. Another one of those very core rights is the Military Rule of Evidence 412. And this is related to excluding evidence about a victim's previous sexual acts. So this is the rape shield law. And those are two very, very core victim rights and much of the litigation that victims' rights attorneys are doing. So it was so important to have this codified that a victim has a right to go up to the Court of Appeals for these to stop the case. And we have to do it. And it ends up, as you see, being similar to what we have in the criminal federal courts, but to finally be able to have this right, because a right is not truly a right in the law if you cannot appeal a violation of it.
Thank you. I'm going to move us forward and ask you to talk a little bit about some specific examples. So I'm going to go ahead and put in the chat. I know some folks have shared in the chat already links to those forms that Freya and Leah have mentioned that sort of summarize victims' rights in military proceedings in a really clear and helpful way. So if you are not familiar with victims' rights and you are not super familiar with the military justice system, those links are a really great place to start breaking down what rights might look like and how they apply. And the question is, when can a victims' rights attorney be really helpful with respect to these rights, whether that's an attorney already in the military, like yourself, Leah, or a civilian victims' rights attorney who's assisting sort of from outside the system to help seek enforcement of those rights?
So I think this really has to start with Freya, because you're working with victims who often don't have an attorney and helping them to understand. So if you can share some of the things that you talk to victims about with why they would want to have an attorney and where they can help that you've seen.
Okay, so when I'm working with a victim in the initial, what we call intake, the very first time that I'm interacting with a victim, oftentimes it can be very chaotic, because we may be responding to a victim at the emergency room, or we are responding to a victim in a emotional crisis in the middle of the night. It is actually very rare for us to be responding to a victim who has just been sexually assaulted. Usually it's at least a few hours later. So when we're talking about legal advice or victims' rights, the first thing I always want to talk to them about right away is medical care. And I know that that's not a legal right, but they do have that resource to medical care. And that's my first number one concern is, are we within that 72-hour window to be able to get them in for a forensic exam if it's indicated? But then I want to talk to them about whether or not they choose to do restricted or unrestricted reporting will determine whether or not they're going to be interacting with law enforcement and whether or not they want to involve the chain of command. Because if they have a restricted report and they choose to tell their commander of their own volition, they still do not have the right to request a military protective order, because that is a right afforded to victims who file unrestricted reports. And that's because that military protective order requires law enforcement notification. And even if the survivor tells their commander, and then the commander abides by their legal obligation to notify law enforcement, and we have an independent investigation over on the one side and a restricted case on the other side, we're not talking to each other in between, because I don't talk to law enforcement about my survivors' cases. They also have the right to have an advocate present. That's a huge one for them, because historically law enforcement has re-victimized victims, and that's where the advocates really came into play, is going with a survivor to that interview that they're having with law enforcement. And if law enforcement starts to berate the witness, starts to ask inappropriate questions, it doesn't matter what kind of a sexual orientation you have or what your sexual preferences are. That's not why you got sexually assaulted. And we can very politely look at our survivor and go, would you like to step out for a drink of water, or something along those terms, so that we can have a conversation with them outside of that interview room. But because I'm not an attorney, because I am not trained, and paralegals in the military cannot even serve as victim advocates because it crosses lines of confidentiality, I do not presume to be able to tell my survivors everything that they need to know about their victims' rights. I tell them, explain everything on the DD Form 2910, which is the election of restricted versus unrestricted. I talk to them about their rights in a generalized manner. And then I recommend that they seek counsel through a special victims counsel, an SVC. And if they tell me that, yes, they do want an SVC, we document that on an additional form. And then I put them in contact with the SVC, unlike family advocacy program, where I often hear that victims dealing with family advocacy are told, hey, this is where the SVC is located. Go seek them out. I make that contact. I am the resource manager as a victim advocate, and I'm providing those resources to my survivors. What did I miss?
What you're hearing is we actually have a very symbiotic relationship between the victim advocate and the victim's attorney. And this is whether it's going to be in a civilian court, if it's going to start in a civilian court and then later get into an administrative process with the military, or remain entirely in the military. Having both a victim advocate and a victim's attorney is essential, because what's going to happen is, particularly in the military context, we bring rank. Most of our survivors are going to not be officers, and all of our victims' attorneys are officers. So when interacting with other military entities, rank matters. And being able to have more rank cannot be helpful, because then it's your big bad attorney who's the one who's saying the questions are stopping and we're going to take a break now. And that can make people feel much more comfortable that someone else got to say it. I even set up safe words. Now, this also works with a victim advocate. But even in those interviews where we have both, it's the victim advocate who's usually holding the hand and handing Kleenex over, who's saying, hey, do you want to go over to the dining facility and we'll go get lunch together, while the attorney is answering calls. So the relationship that I'll have as the victim's attorney is going to be much more arm's length. Also, because we have a rank difference, we need to, and my role is different. And the victim advocate is going to be the one who can actually be there to physically drive a victim, because it's so emotional after, say, a SANE exam or after that initial interview with law enforcement. I won't be the one that's doing that. I won't be accompanying them to lunch, but somebody needs to be doing that, and to be able to be there as more of a peer to assist them. Also, when a case is going through the civilian court process, that's where having our civilian counterparts becomes vital. I am not allowed to represent my client in civilian court. In those jurisdictions where they are prosecuting the case because the perpetrator was civilian or was not in a military status, or there was joint jurisdiction and civilian court got the jurisdiction and it's going there, I am not allowed to assert Marcy's rights on behalf of my victim. I am not allowed to go get a civilian protective order on behalf of my victim. When my client needs those services, we're going to be reaching out to often pro bono referral programs, to other attorney resources to help us. And first and foremost, they're going to be working with a civilian victim advocate, and I'm going to be advising with the clients. Yes, you have your military victim advocate who's going to help you, but you also want a civilian victim advocate. Your military victim advocate knows who's who on that military installation, is happy to take you from those medical appointments to the mental health appointments to get things taken care of. But that civilian victim advocate is going to be able to tell you what's going on in the case, what's the personality of the people at play, because they see the courthouse all the time. They're going to be used to the civilian court lingo to be able to interpret those things and keep you informed about what's going on. So the dual roles and the different roles of a victim advocate versus the attorney means that we work together, and it is so helpful to have both. And that's why we each will be working with these organizations differently. But along those steps, where there is legal advice to be given, that's where we'll take the pause and we'll actually give legal advice. You have a right to say no to this. You have a right to advocate for this. I can write a memo on your behalf to request that the civilians get jurisdiction on this case and that the military relinquish jurisdiction. I can write a request that you would like to no longer participate and it's going to have a different weight, or you would like to have, something to go along with a clemency request after sentencing. Those are things where an attorney is going to be vital for. And at the same time, having someone to hold your hand after that, when that sentence is being read, is also equally vital, and where the victim advocate's going to be helping out, because they know what you've been going through. They've been there with you, wearing sometimes the exact same rank.
Thank you both. That's a very important point. Working together between advocates and attorneys is important, whether or not that's in the military system or the civilian system. Victims benefit both when they have access to both types of service.